This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
We're still on illegal acts, and we're into the last of the illegal acts. We looked at wrongful trading, 2 offences of fraudulent trading. We looked at insider dealing, and I think that was it, wasn't it? So we looked at 4 of them. This is the 5th one. Oh, money laundering, that was the 5th. And now we're into bribery, the 6th of the illegal activities. Bribery is it's not a new concept by any means. It's not a new concept, but it's new in legislation. 2010, the Bribery Act was introduced in the United Kingdom Parliament, and it applies to United Kingdom personnel wherever they may be in the world. So the United Kingdom agents of UK companies travelling overseas may deem it necessary in order to, for instance, gain an audience with the local powers that be, the mayor, the president, the king, the important movers and shakers in these overseas countries away from the UK. This Bribery Act applies to the UK people in these overseas countries, and it is an offence for them to pay money to anybody who is then going to facilitate an audience with the king, the president, the prime minister, whoever it may be. So Bribery Act is an all-encompassing, as a pan-world piece of legislation that affects UK citizens. Other European countries have similar legislation, and there comes a time when hope springs eternal, that one can only hope that in order that people can work on what is called a level playing field, that no unfair advantage will be made available, and that it will be strictly illegal, involving periods of imprisonment where it is found that anybody has been offering a bribe. And the same actually applies to people receiving a bribe. Hopefully they ought to no longer be the recipient of such money. And if I remember, I'll have a word or two about that at the end of the lecture. So anyway, Bribery Act targets both bribery and corruption, and there are 4 offences. There's the obvious one about bribing another person. I'll do that in this stuff. There's the obvious offence about bribing another person. Keep that in mind. Just hold that thought, because the second offence is receiving a bribe. I think both of those are quite clearly obvious, aren't they? That if you receive a bribe, then you're committing an offence. You're encouraging the act. You're encouraging the continuance of the process of bribery and corruption. Now, this third one intrigues me, and it continues to intrigue me, and has intrigued me ever since the 2010 Act was passed, because the third offence is bribing a foreign public official, an FPO I call them, to bribe a foreign public official. Well, am I not right that a foreign public official is a person? And therefore, did we not cover this criminal activity by considering the first one, bribing another person who happens to be a foreign public official? I don't understand. I'm a simple man. I don't understand why we have this third category. The only reason I can think is that it's rather more heavy in terms of punishments, but to my knowledge it isn't. It's still up to 10 years imprisonment, no matter what the crime. I suppose it's potentially the case that we can vary the punishment maybe at some time in the future and say bribing foreign public officials is a more heinous crime. I don't know, do you know the word heinous? It's a more heinous crime than simply bribing a the buying officer of a company in the next town. So bribing a foreign public official, that's the third category, and we'll look at that. I'll look at it in more detail coming up. And the fourth one is a commercial organisation failing to prevent bribery, and again, I'll have a look at that in greater detail. So bribing is offering financial or other advantage, not necessarily cash. It could be a car or a holiday or a trip to the zoo for you and your family, or it could be any financial or other advantage made available by one person to another, in order that the recipient, not necessarily immediately, not in direct exchange, but so that the recipient will remember you. When you're traveling as a traveling salesman, and you're trying to sell and procure orders for the goods and products of your employer, and you go to someone and say, "Oh, look at this! I happen to have 2 mobile phones. One was given to me in exchange by Vodafone. And then when I looked at it, it was actually all right. And so I've got one, and here's another one, and I don't need it. Would you like a mobile phone?" So giving presents of value and incidental gifts are not important. A bottle of spirit, a bottle of perfume, as long as it's not wildly expensive, that's okay. But anything beyond de minimis limits, do you know the word de minimis? Do you know that expression? De minimis, anything of negligible or of low value is not considered worthy of wasting time. But otherwise, if it is of substantial value, then a flight to Disney World in the United States, in California, or even in Paris, a flight for you and your family to Paris would be considered excessive, and it would be considered a bribe, even though the recipient may not themselves realize it, may not themselves be in a position to return the favor or act on the bribe. They may no longer be the purchasing officer of the company, but you are trying to get into their good books in order to procure orders for your employer's products. So bribing is offering financial or other advantage to perform a relevant function or activity. And we need to know, therefore, what are relevant functions and activities. And there they are listed. There's any function of a public nature, any activity connected with a business, any activity performed in the course of a person's employment, or any activity performed by or on behalf of other persons. So let's get down to basics and say it's seeking to obtain an unfair advantage by paying goods or services or providing benefits to people who are in a position to give you that unfair advantage, to give you a push ahead of the competition. These relevant functions or activities may be anywhere in the world. This Bribery Act, as I mentioned, this Bribery Act applies to British people, United Kingdom people, wherever they are in the world. It's not confined to the shores of Great Britain, United Kingdom. So let's move on. Bribing a foreign public official. Presidents, kings, prime ministers, Department of Trade ministers, members of the government, foreign public officials, and offering bribes to them or seeking to obtain an advantage by giving them some financial or other benefit. So it's an offence to offer directly or indirectly a financial or other advantage to an FPO, intending to influence them in gaining business or an advantage in connection with your business. If you're in a competitive situation and you're tendering and you're trying to buy an acreage or hectareage of land because you believe that there are oil reserves underneath that specific land, would it not be sensible to pay a substantial amount into the hands of the Home Secretary of the country in which this oil, this land is thought to be? Would it? Yeah, it would. It would potentially gain you an advantage. That will be an unfair advantage, and it will be a criminal activity. It will be illegal. It shouldn't happen. To my knowledge, well, you know, it does happen. You don't have to listen to BBC News for too many evenings to hear about bribery and corruption. So it does happen. It's a shame that the world is continuing in its corrupt activities, that some countries are notable, have the reputation for major corruption. And I have to say that I have lived recently, not now, lived recently where it was open policy to bribe a policeman. I didn't, but where it was open policy to bribe a policeman who stopped you for no apparent offence, but they were going to find an offence unless you slipped them some currency of their local country. So it does happen. I didn't do it. They asked me and I said no, book me, write me a note, I'll go to court because I don't think I was guilty of the offence. And if you stand up against them, the likelihood is they will let you go. So it's an offence to offer, directly or indirectly. An FPO is a person that holds an administrative, legislative or judicial position outside the UK. And so that's the offence of bribing a foreign public official. This next line should be in this typing. It's the commercial organisation failing. It's the fourth one, isn't it? It's this one, and it should be as highlighted as the bribing another person, receiving a bribe, bribing a foreign public official. Because the commercial organisation failing is the fourth offence under the Bribery Act. And it says a company or partnership is liable if an agent of theirs, employee or subsidiary, bribes another person intending to gain a benefit for the employer company. There has to be adequate, sufficient, appropriate procedures in place that will deter or prevent or protect this agent from the temptation of wanting to offer a bribe. The company should have protective measures, protective structure in order to protect this employee from thinking it was acceptable to offer a bribe. Defense, if the company, in this particular situation, if the company can show that they did have what they thought were adequate procedures in place, appropriate to the level of risk. And adequate procedures has got 6 guiding principles, and they're on this next page, and the 6 principles are proportionate procedures. You're not likely to get any advantage from OpenTuition by offering me a bribe. It's not going to happen. You're not going to, although we have, each of us has separately been offered in the past money in order to personally mock exam scripts from students. If you think that we have in excess of 400,000 students, there is no way that any one of us is going to open that door. It could not be worth our while for you to even think about offering us a bribe. We don't have anything that we can offer in order to give you some advantage. So forget about it. So proportionate procedures, OpenTuition does have its own proportionate procedures. We just say to each other, if that chance of anybody wanting to offer us a bribe, it's not going to happen. But there are companies where, oil companies particularly, where people out in the field would surely be tempted to offer substantial amounts of money to those foreign public officials that have the authority to grant licenses for oil companies to commence their drilling and commence their oil testing for wells. Commitment by management. Management should assess the nature and extent of risks faced and develop appropriate risk management, risk awareness and risk management is part of, when you get there, it's part of, well, you won't get it. It's part of the exam called P1, which is governance, risk and ethics. But by the time you're doing P1 will have disappeared because it's being merged with P3 into one other separate exam called strategic business leader. But P1 does talk about risk management, governance, risk and ethics, and risk management, and risk awareness, and risk aversion are all part of the P1 exam, and presumably will become part of strategic business leader. Due diligence. The company should apply due diligence procedures in respect of a company personnel who are at the greatest risk of offering bribes. People out in the field whose job it is to try and secure licenses. They're the people most likely to be tempted by the possibility of gaining an advantage if they offer a bribe, and there should be due diligence procedures within the company to seek to prevent that. Then what happens? The agent offers to pay the bribe. He then goes back to the company and says, if we pay $500,000 to this person, then we'll get the license, or we will have an audience with the president. And the executives of that company should say no, and probably we do not want to work with you anymore as an employee, as an agent of ours. We don't want to work with you because you are enticing and you are encouraging us to break the law, the Bribery Act of 2010. Monitoring communication. This is education. This is education and training that the company ought to have continuing. It's like ACCA requires you to have continuing professional development even after you've qualified. And similarly with the Bribery Act, this is one of the adequate and appropriate procedures. There should be training and communication and education carried on within the company in order to make sure that all employees that are at risk are fully up to date with reference to the sanctions against this concept of offering bribes. Monitoring and review. Procedures should be regularly reviewed and improved as necessary, but this is the same with any system. When you come to F8 and you learn about internal control systems, these have to be continuously reviewed, updated, improved, and it's one of the jobs of the auditor to seek to establish and to show how systems can be improved and make those recommendations to clients. Adequacy matter for the court to decide. I think they're adequate, says I. The court says I don't think they're adequate at all. So in that situation, adequacy is for the court to make their decision to see whether it is or is not adequate procedures. Hospitality, reasonable and proportionate. It's not prohibited. If you buy someone, I don't know, Christmas hamper, or an invitation to the corporate entertainment day, where you get all the buying officers from all the different companies that you want to supply, and you invite them all for a day at the local golf course for a game of golf, or a day at the race course to watch the horses racing. That's acceptable, as long as it's proportionate. That would be out of proportion for a poor, small company like OpenTuition, but it would be well within immateriality if it was somebody like Shell UK or British Telecom. And finally, the penalties. Individuals found guilty faces imprisonment up to 10 years. Guilty company is liable to an unlimited fine, but in addition there's reputation loss, because people may no longer wish to deal with that company, where we know that that company is potentially corrupt. Being a cynic, it may be that some people say, oh, the company is potentially corrupt, maybe we should be dealing with them. But that is cynical, and that's not, hopefully, it's not something that will dissipate through the profession of accountancy. And potentially civil claims against the directors for failing to implement adequate procedures. Just very, very finally, before I come back to what I was going to say, and I said I might, if I remember, I might mention it at the end. Just finally then, Munir Patel is the first conviction. This was, I think, somewhere in 2012, where Munir Patel was convicted. He'd received £500 from a person who was in court facing a penalty for a driving offence, and he'd paid Munir Patel a person who had a position to do this, for suppressing the detailed criminal record of an earlier driving offence. Munir Patel is did serve 3 years, and damaged his reputation, and lost his job, and now finds it difficult to get another job, because He's a dishonest person. He cannot be trusted. Okay. There was an article. I thought it was a very clever article, but when I've mentioned it in the past, people have said, no, that's not clever at all. I think it's a very clever idea. The penalty for under the Bribery Act is for, let's say I'm offering money to you. It's for me to offer you money and for you to accept the bribe. It's an offence for me to offer the bribe. So we're both of us guilty. That being so, it is in neither your interest nor in my interest for this to be disclosed, for this to be discovered. So you're not going to say anything, and I'm not going to say anything, so life can go on. This is only hypothetical. I'm not accusing you in any way of being corrupt, in the same way that I'm not accusing me of being corrupt. So it's in both our interests to stay very quiet about this bribe that has been offered and received. So it was a suggestion that it would continue to be an offence for a person to receive a bribe, but it wouldn't be an offence for a person to offer a bribe. So here's me offering it to you, and you receive it, you've committed an offence, but I haven't. And in fact, it's then in my interest, because you could then develop the thought that said, in fact, anyone receiving a bribe upon discovery shall not only forfeit the money and pay it back to the person that offered it, but shall pay the same amount by way of penalty into the public coffers, into the public purse, and they themselves will be guilty of a criminal offence for receiving a bribe, but the person who blew the whistle, the person offering and giving the bribe, would not have any liability. Now there is an interesting concept, because it means that I can go around offering and you receive, or possibly not you, but you receive what you receive, and you are guilty and I'm not. And it's then in my interests, having now been granted the license to do the drilling for oil, it's now in my interest to disclose to the authorities that you have received a bribe, and that I can get that money back, and the same amount will go into the public purse, and you will lose your job, and maybe even worse, in some countries, may not just be your job that's at risk, it could be your life that's at risk. If the president, God bless these corrupt presidents, if the president discovered that you were taking bribes and not disclosing them or sharing them with him, so the recipient of the bribe would be found guilty, the offeror would be exonerated from blame. And that, I think, is an interesting proposition. But it doesn't exist. It's just me stimulating your interest buds. And that's it for this chapter.